pleasant day to you and welcome to this edition of Inside Parliament. As you're quite aware that Parliament sat on Thursday, November the 22nd, and it was very momentous because we were awaiting the decision whether Minister Rohi would be gagged. And joining me on this edition is the Honorable Anil Nandlall, Minister of Legal Affairs. Minister Nandlall, pleasant day to you.
Thank you.
I know that yesterday the nation was awaiting the decision of whether Minister Rohi would be gagged in the future. Before we get into the motion itself, tell us exactly what transpired and what it means to national development and the way forward.
Well, I think the more convenient point that I should commence is by pointing out that of all the short years that I spent in the National Assembly, Thursday's sitting, the 22nd of November, would go down as perhaps the most controversial sittings in many respects. Firstly, it was a government day for business, or government day of business in the National Assembly. We changed the standing orders to allow for opposition to have their own day, and that day is, I believe, a specified day in the month, and every other day that Parliament sits is to deal with government's business. You had, during the course of government's business, an intervention made by Mr. Basil Williams of the APNU to suspend all the standing orders and to essentially rearrange the agenda fixed for that day's sitting of the Parliament and to catapult into action a motion which was filed the very day. At least it was brought to the notice of the government side the very day of that sitting. We, of course, advanced various objections as to why, one, the standing orders ought not to be suspended, two, why government business should not be relegated, three, why opposition business ought not to take precedence over government business on a day set aside for government business, and four, that and four, that the matter that was sought to be brought to be discussed is a motion which carries grave consequences, and therefore the government side is entitled to a longer period of notice. Those, in a nutshell, were the objections advanced by the government. As you know, they were all overruled. And again, we have a history of new precedents being created, whereby all the prior precedents and all the new standing orders which we have put in place
Just
for
want
the
to pick up
smooth
in here.
running of
When
the...
you refer to we, when the changes were made to the standing order, was it done in consultation with the members of the opposition?
It was, yes, it was done by a series of process which involved the material and significant inputs of the opposition. When we maintained a majority in the Parliament, we ensured that certain committees which direct the affairs of the Parliament, for example, the Parliamentary Management Committee, we ensured that there was parity, that there was balance, that notwithstanding the government had a majority, we ensured that there was parity of representation from the opposition as well, so that you would have a cohesive and comprehensive representation of the constituent members of the Assembly partaking in an exercise to run the affairs of the Assembly. That was the principle which we embraced as a majoritarian government. Of course, when we lost that majority, everything else was turned upside down, and the majority from the opposition predominated and continues to predominate every facet of parliamentary life. last Thursday, of course, was a manifestation of that. So, getting back to where I left off, you have all of these things which we have put in place, and the new standing orders and so on, everything was suspended, and the Speaker allowed, by a ruling, that the motion be proceeded with. Then I raised, as the motion was about to commence by the mover of the motion, the Honorable Leader of the Opposition, Mr. David Granger, I then rose and raised another set of objections. I said that there was a court action that dealt directly with this issue of whether the no confidence motion, which this motion that was being promulgated in the Assembly seeks to enforce by gagging Minister Rohi pursuant to that no confidence motion, that no confidence motion, which is the genesis of this motion, is being challenged in the court, that there is a standing order that precludes the Parliament from proceeding on a motion, which motion the subject matter of which is the subject matter of pending legal proceedings. And I cited that standing order. And secondly, I cited constitutional provisions which show that, which confer upon Minister Rohi a fundamental right to speak and to express himself, and a constitutional provision also which deals with the right of a member to perform his duties as a member of Parliament, and that this motion would seek to infract all those constitutional provisions. I again explained in great details that ours is a system which, though we enjoy a degree of sovereignty and freedom in the Parliament in terms of how the Parliament regulates its own procedures, and in terms of the powers which the Parliament is empowered to exercise, that though we have that freedom must be viewed against a doctrine called constitutional supremacy, where our Constitution is declared to be the supreme law of the land, and indeed it is that very Constitution which creates the Parliament and gives the Parliament all the powers which the Parliament exercises, and says to the Parliament that you are to enjoy freedom subject to the Constitution itself. And that fundamental legal concept, try as I did, I was unable to get the majority of the House to appreciate that concept. It is quite unfortunate that so many of them are lawyers, and one would expect that they would appreciate that quite quickly. They keep going back to what is the tradition in the United Kingdom, and that we are bound to follow those traditions. They keep referring to cases decided by the English courts, and that we must follow those cases.
I want to ask here, because you're talking about cases, and if you recall what happened on Thursday in Parliament, a case was referred to by Mr. Kamrat Ramjatan, the Gadraj
Yes.
Jagan. Was it appropriate at that time? Because I think that case
That is the point.
1963.
That's the point I'm going to make. That all their reference, though we as a Commonwealth jurisdiction and as a product, so to speak, a historical product of the English Parliament by virtue of our colonial history, when we got independence, not only did we sever our links politically, but we severed our links legally with England, and England gave us a constitution. And it is that constitution that differentiates us from the position in England. And it is that constitution that creates this parliament. Prior to that, we had a colonial parliament. So every reference to a precedent followed by the House of Commons in England or an English authority must be read with due appreciation of the fact that it was decided under a different legal system, fundamentally a legal system in which Parliament is supreme. That is the British position. So while you are free to refer to British customs, British practices, British precedents, you have to be wary of the fact that you must accept those precedents, traditions, and practices subject to the caveat that you are dealing now with a constitution that is supreme, and that Britain has no constitution, and Britain has a parliament that is supreme. In other words, the British Parliament is much more powerful. In fact, it is an omnipotent parliament. So you cannot wholesale take these traditions and precedents from the British Parliament and try to transpose them on our Parliament here without passing it through the litmus test of the Constitution to see whether it satisfies the constitutional requirements of our constitutional supremacy doctrine. And preach as I did last night, it all fell on deaf ears, and reliance was continuously placed on the British authorities and the case of Jagan and Gadraj, not recognizing that Jagan and Gadraj dealt with a legal system at the time in Guyana in 1963, where we were a supreme parliament and where we had no constitution because we were a colony of Britain. And the lawyer who used that example, Mr. Kemraj Ramjatan, failed abysmally to appreciate that fundamental but basic distinction. And when I pointed that out to him, he continues to say, unaffected by the arguments which are being advanced to him and the constitutional provisions which are being cited, he essentially said, and I invited the camera at one time to capture him saying that, because he essentially said that the majority of one in this parliament is supreme, that they will do whatever they want, that the rules of natural justice and the rules of law do not apply to the parliament, that they can overrule them by the majority of one, that the constitution does not apply to them because they have freedom in that parliament and they can use that numerical strength of a one-seat majority to essentially, because that is the sum total of his argument, subvert the Constitution, reject the Constitution, and they have that political will. And they claim that that is what the people of Guyana voted for and gave them that majority to invest them in that power to basically, in his own argument, if you take them to their logical conclusion, to subvert the legal process. He even at one point in time said that the courts have no business in inquiring what they do in the parliament.
I want to ask the question, we're talking about the courts. Let's assume that the case is given speedy trial and it is not in favor of the opposition. How does that affect what happens in Parliament?
That is precisely why the standing orders say that you must not proceed to debate a matter, the subject of which is in a court matter. That is precisely the reason. Suppose the court is to rule in my favor and declare the no confidence motion null and void and of no binding legal and constitutional effect. What is the impact of that ruling now on everything that we have done in the parliament last Thursday? It would render unlawful and a nullity and a waste of time everything that we have done in that parliament last Thursday.
Just want to ask the question. We started in July with a motion of no confidence against Minister Rohi. Now we have ended up reaching to the Privilege Committee of the National Assembly. Explain the process and how the people of Guyana, we are losing.
Recall the no confidence motion was propelled again in a most summary manner, again not complying with any of the notice periods which are required by the standing orders to put such a motion. So again, when it was introduced, you had a suspension of all the standing orders and a catapultion of this no confidence motion as a priority matter to be dealt with immediately by the Assembly. The no confidence motion, as viewers will recall, arose out of the shooting which occurred in Linden, where 3 persons died and several persons were injured. The no confidence motion on its face, in the language used, and in the arguments advanced in the Assembly, that no confidence motion, based upon the sentiments expressed both in the motion and on the floor when it was being debated, was predicated upon a belief, a suspicion, and a basis that Minister Rohi had given instructions to the police to shoot. Recall that is how all this thing happened. At that time we said, look, we have committed ourselves to a commission of inquiry. We have made, and in a joint process, we have said that that commission of inquiry has the authority to inquire into Minister Rohi's involvement, if any, in the Linden incident. We said, therefore, that it is preemptive, it is prejudicial to deal with this matter in the Parliament when the Commission is seized of the matter. They rejected our arguments again, and in an unprincipled fashion proceeded to deal with the motion. Readers would recall that they went to the Commission also, and when the opportunity was presented to them to bring forth the evidence which they claimed they had to implicate Minister Rohi and to connect him to the shooting at Linden, they miserably failed to do so. So, and that process is still ongoing. The Commission has not yet ruled. But what was patently obvious is that no evidence was produced whatsoever which would tend to implicate in any material way Minister Rohi in the Linden incident. That is beyond disputation. Then you have a motion now that is devoid of any factual or evidential basis. And that is the motion, using their numerical strength, they voted and caused this no confidence motion to be issued against Minister Rohi. So Minister Rohi is convicted for a wrong allegedly which he committed in Linden, not in the National Assembly, but somewhere in Linden, though not one scintilla of evidence has been adduced either in the Assembly or in the Commission of Inquiry, which would tend to support an allegation that he was somehow involved. But more fundamentally, a person under the standing orders can only be committed to the Committee of Privilege if he has violated a privilege, if he has basically behaved in a contumacious manner in the assembly, if he has behaved disorderly, if he has violated some ruling, something in the assembly, you put the offense to the person.
All right, you said violation of a ruling or would have disobeyed an instruction in the assembly.
Yes.
Let's recall in July a no confidence motion was
Yes.
passed. Could it be that the opposition held that Minister Rohi had disobeyed, given the fact that the motion was successful against him at that time?
But the motion declared no confidence against him. What effect that has is a matter that is before the court. The motion doesn't say that Minister Rohi cannot speak. The motion says that they have no confidence in him. Therefore, if you don't have no confidence in him, I suppose that you don't have to support what he says, what he brings to the assembly. You don't have to listen to him when he speaks. You can leave. But he has a right as a member of the assembly to perform the functions which the Constitution mandates him to perform as a member of the assembly. You and your no confidence has nothing to do with that. And that is what there seem not to be the capability of appreciating. That is my point. What wrong, what offense has he committed? You said that you have no confidence in him. Okay, not a problem. You have no confidence in him. He has done nothing.
However,
Having a no, that is why the speaker ruled in the way that he ruled the first time. The members of the assembly having a no confidence in a particular member is not an offense nowhere in the Constitution. It is not an offense nowhere in the standing orders. That is why the speaker was forced to rule in the way that he ruled, because he cannot find a power to discipline, to sanction, to prohibit Minister Rohi from speaking, either in the law, in the standing order, or in the Constitution. That was his ruling. So, why are you sending him to the Privileges Committee? The speaker yesterday, Thursday, ruled two things. One, that he's committing him to the privilege. He's committing the issue to the Privileges Committee. What issue? Is it the issue that Minister Rohi cannot speak? Is what is going to the Privileges Committee? Minister Rohi must be told in clear language what offense he's being sent to the Privileges Committee for. I heard the speaker say that the issue is being sent to the Privileges Committee, but the issue doesn't exist in isolation of Clement James Rohi, Minister of Home Affairs and Member of Parliament. The issue didn't fall out of the sky. The issue is inseparable and intricately entwined in a Member of Parliament and the person who holds responsibility for Home Affairs. So I don't know how you can send the issue without sending the member. Who will defend the issue?
No, I want to ask a question here. The Ministry of Home Affairs is very critical to ensure working with other partners to maintain national security and law and order in the country. How long will it take for the privileged committee to come up with their findings before it is decided whether Minister Rohi will be able to speak in Parliament or he will be
Be-
asked
before
for?
before I deal with that, I want to deal with the second limb of the Speaker's ruling. Though the Speaker has committed the matter to the Privileges Committee, he has nonetheless imposed a sanction on Minister Rohi in the form of a prohibition which prevents Minister Rohi from presenting any bills or making any presentations in his own name to the National Assembly. So while the Speaker, in this very circuitous manner, sends this matter, this issue, according to him, to be determined by a privileges committee or to be addressed by a privileges committee, the Speaker proceeds to impose a sanction, thereby prohibiting the minister from functioning and violating Article 171 of the Constitution, which says that any member of the National Assembly can bring any bill or can bring any motion to the National Assembly. Well, Minister Rohi cannot. And I don't know where the Speaker has found that power to interfere and deny Minister Rohi a right guaranteed to him by Article 171 of the Constitution. The Speaker, in his ruling, did not say on what basis he has accumulated this power. In my presentation to him, I said, Mr. Speaker, you have said in your previous ruling that you have no power to prohibit the member from speaking. And in a very strange way, you have nonetheless invited them to bring a substantive motion to prohibit him from speaking. Well, they have accepted your invitation and they have presented to you this substantive motion to prevent him from speaking. Tell the National Assembly now that this substantive motion is before you, where are you going to get the power? You didn't have it before. And you said you didn't have it before. Under the law, you don't have it. Under the standing orders, you don't have it. Under the Constitution, you don't have it. Now that the motion is before you, where are you going to get it from? The motion doesn't give it to you. Motion can't give a speaker power. Motion can't give the assembly power. The assembly has to get its power either from the Constitution or the standing order, especially a power to impose a sanction on a member of the assembly. So he didn't say where he's getting this power from. So you have that very strange state of affairs and the travesty whereby a member of the National Assembly who holds a ministerial portfolio cannot perform the functions which devolves upon him by the Constitution and by the several pieces of legislation of this land, because the Home Affairs Minister has several statutory functions to perform. He cannot perform it by a ruling from the Speaker. And that ruling, that sanction of prohibition, was imposed though the minister was not told what is the offense which he has committed. And secondly, no due process was extended to the minister. You would note, you were present yesterday in the assembly, not an invitation was extended to Minister Rohi to say a single word in his defense by the Speaker.
I believe the Speaker has also alluded to the fact that he too supports that one has the right to defend himself.
That is the contradiction. The Speaker says yes, he is deeply concerned about due process. You recall him saying so. Well, due process is inherent in our legal system and expressed manifestly in several pieces of legislation and the Constitution itself and the standing orders. But despite the Speaker's deep concerns for due process, the Speaker proceeds to impose a prohibition on Minister Rohi without due process. Without due process.
But it brings us back to the question, how long will it take?
Well,
The privileged committee.
you began to ask me about the importance of the Home Affairs Ministry and what impact this ruling would have on the ability of the minister to discharge the functions of his office, right? And the time that it will take. Well, the chairman of the Privileges Committee is normally, the speaker. I suppose the speaker will determine when the committee will sit and at what intervals and so on. Significantly, the committee, in its present composition, has a majority of opposition members. So you don't have to be a rocket scientist to determine how or to predict how the Privileges Committee will rule. Because you have a majority of members of that committee who are going to judge their own case. You have a majority of members of the opposition who want to stop Minister Rohi from speaking. And that issue was sent to them to determine how you expect they will rule if you are to predict and your life is on it. They are going to rule in a predictable manner. They are going to gag Minister Rohi. The speaker has already done so. They are going to complete the process. But I don't have an idea how long it will take for that process to be completed. But in the interregnum, and as I said, I can reasonably predict, all things being equal, what that outcome will be. The point is, during that time and even thereafter, if I'm to reasonably predict accurately how the outcome will be, you will have a Minister of Home Affairs who is essentially wrongfully disbarred and debarred from performing the functions of his office, which the Constitution permits him to do. I keep saying Constitution because there is nothing that National Assembly can do which is violative of the Constitution and which can withstand legal scrutiny. Just recently, and these are basic legal principles which I have to keep reciting because obviously they are being forgotten. Only recently, the National Assembly, in a unanimous vote, passed the Sexual Offences Act. And the Chief Justice, a single judge, struck down several sections of that act and says that it is unconstitutional. One of the matters on the agenda for Thursday was an amendment to correct what the Chief Justice has ruled are unconstitutional provisions of that act. I cite that example to show you the majesty of the Constitution over and above the sovereignty of Parliament and the role of the High Court as the sentinel of the Constitution to look over the entire process and to see whether the Parliament or any institution of this country, including the executive, to see in their behavior and in the conduct of their affairs whether they are acting in a manner contrary to or in violation of the Constitution, and to strike down those actions. That is an undisputed power of the High Court in our constitutional system. Yet you have lawyers in that parliament standing up and saying on live television, because television cameras were rolling, I don't know whether it was being broadcast live, that the court has nothing to do with the way parliament is functioning and that they can use a one seat majority and their numerical strength to do what they wish in the National Assembly.
But the masses were quite concerned about the way forward. What is the way forward to ensure that the interest of the people of Guyana is represented?
The masses should look at what is going on in the National Assembly and recognize that this opposition are in the opposition. They are not in government. And look at how they are behaving. And judge for themselves if these are the people who want to govern this country. And to consider for themselves what will happen in this country if this is to take place. The one institution over which they exercise control is the parliament, and they want to say to the nation and demonstrate to the nation that that institution is above the law, is above the constitution, and that institution can run the government and can run everything else. Because Mr. Kemran Ramjatan said very clearly that one by one they will knock off ministers. Now that is a statement which is an expression of the mentality of the opposition. The speaker, I understand, upbraided him. But that is the thinking. So if they are in the opposition and they want to dismiss ministers, they are subverting the constitution. They are saying that they are powerful and above the courts and that the courts can't control them. Well, imagine what will happen in this country if they will ever hold government. As I said in the parliament yesterday, it appears as though there is a belief residing deeply within the opposition that they can pass a motion and take a person's house or possibly dismiss the president. Because if you take it by its logical conclusion, it seems to be going in that direction.
But
Because they feel that they can dismiss a minister. What is wrong? What prevents them from convincing themselves that they can't dismiss the president?
I suppose that the government welcomes the opposition policing the work of the administration.
I have said that the opposition has a crucial constitutional role to play. Firstly, they must recognize that they are the opposition. That's the problem here. They don't recognize that they are the opposition. And the opposition has a role to play. They have two functions to perform. They have a function to perform in terms of scrutinizing government's conduct and ensure that government is acting within the confines of the law and the constitution, and government is not abusing the constitutional rights of the citizens and not abusing governmental power. They have a second function, which is a financial function, in which they have to scrutinize government's spending of taxpayers' dollars. And if they have to exercise that power in the Committee of Supply, they have to exercise that power on the floor of the National Assembly, and they have to exercise that power in the Public Accounts Committee. That or those are essentially what the functions of the opposition are. But this is an opposition that has convinced themselves that they have the power to dismiss a minister, to stop a member from speaking, I said to them that even in the height of Fobbs Barnum's dictatorship and Desmond Hyde's dictatorship, when they controlled two-thirds of the parliament, those two gentlemen who were lawyers never felt that they have the power to dismiss members of parliament or stop them from speaking unless they committed a wrong within the precincts of the assembly. Those two men never did that. But you have a set of people here who feel that they have that power.
Finally, and very quickly, as we wrap up, do you believe that the procedure in the parliament was correct?
No, I believe that what transpired in the parliament was a complete travesty. A complete travesty. That the procedures were violated. The motion in the first place was inadmissible, not supposed to have been entertained. The no confidence motion was inadmissible. So I wrote an article in which I said, ex nihilo nihil fit, out of nothing cometh nothing. So if you had a nullity in the beginning, everything that will flow from it will be a nullity. The no confidence motion which was passed was a nullity. And I explained in several television programs why. And everything that is consequent upon that no confidence motion is a nullity. And I basically have said that to the speaker. But the speaker says that I like theatrics and I like flair and so on. And that what I say is not of substance. But it's not me. I am not saying these things because I want to say them. I am saying these things and I am citing the law. I am citing the provisions of the Constitution. I am citing cases which support me. The other side are not doing so. They are citing positions in London which are wholly inapplicable to our situation. Why you think they're not citing examples from the Caribbean? Because they cannot. They cannot find examples in the Caribbean or in countries that have a written constitution which supports them. They can't find that. So they go and they find convenient examples, wrong as they are, to fool who? They have a majority anyhow. So you don't have to convince. Reason is obviously not operating within the realm of the assembly. So you don't have to speak and bring British precedents. Just rule as you say you have the power to do and subvert the entire process.
Minister, on this note, we have to wrap up, and we once again say thank you for joining us. Join us for the next edition when we continue to discuss inside Parliament.